Hi everyone, my name is Tan Ying Sheng from Taylor Law School and I'll be presenting on the maxim of equity. Maxim, equity will not perfect an imperfect gift, and equity will not assist a volunteer are cornerstone of equity, a legal disciplines that emphasize justice and fairness. These tenets serve as guidelines for courts when they administer equitable remedies and establish the rights and duties of parties to legal disputes. It depends on the particular situation's context and circumstances as to whether these maxims go against a settler intentions. Now, I'll be giving you guys a brief explanation on the maxims. Sir George Jessel expressed the equitable maxim, equity will not perfect an imperfect gift, in Richards and Delbridge. The maxim equity will not perfect an imperfect gift refers to the fact that equity won't step in to fix or complete a gift that's illegally deficient or faulty. Equity will not intervene to enforce or perfect a gift if the settler's purpose to make it is not adequately expressed or if certain requirements are not met. Equity might not be able to enforce a property transfer, for instance, if a settler tries to transfer a piece of property but doesn't follow the appropriate legal procedures. In general, a promise to make a gift without consideration is not enforceable. It's only a gratuitous promise. The maxim equity will not aid a volunteer signifies that equity will not provide remedies to someone who is considered a volunteer. A volunteer is someone who hasn't given any consideration for a bargain. According to this principle, equity will not enforce any covenant to create a trust for a volunteer. Equity typically will not compel another party to compensate or reward someone who freely performs an act or offers a benefit without being required to do so by law. This principle bars anyone from alleging unfair enrichment or asking for equitable relief while they behave illegally. In the case of Corin and Patton, Mason Chief Justice and McHugh Justice discussed this maxim and reached a mutual agreement where this maxim and the related maxim equity will not perfect an imperfect gift are primarily associated with the rule that a voluntary covenant is not enforceable in equity, subject to some established exception. Now, I'll be moving on to constitution of a trust. When a settler desires to establish the trust, three certainties must be present for the trust to be validly created. The trustee must also own the legal title to the property held in the trust. This is because it is impossible for someone to provide something that doesn't exist to someone else in its entirety. Another condition for the formation of an explicit trust is the intention to create the trust. However, it is insufficient by itself. It won't be completed until the trustee receives the property. Due to the connected and revert maxim of equity, equity will not assist a volunteer and equity will not perfect an imperfect gift. Unless it falls within the exceptions, equity cannot provide assistance if the trust is not properly created. There are three modes of benefiting an intended donee. The first is an outright transfer from the settler to the donee, and this mode is for the constitution of a gift. The other two modes is constitution by trust, which is by the settler transferring the property to the trustee, and declaration of self as trustee. The question that typically arises in relation to the establishment of trust is whether or not the court can give effect to a failed gift by designating it as a trust. The court usually will not allow it because equity will not perfect an imperfect gift. This is because equity will not assist a volunteer. Thus, it can be seen that these two maxims are correlated to each other. This can be seen in a landmark case of Milroy and Lord, where the Lord Justice Turner laid down the principles of the maxim. Now, I'll be talking about the case of Milroy and Lord. In this case, by giving shares to Lord to be held in trust for Milroy, the settler intended to establish a trust. The settler failed to transfer legal title to the trustee due to signing the wrong form of transfer. It was argued that the beneficiary title should still be transferred as per the intention of the settler. It was held that the settler's intention was to vest the shares in Lord as trustee and not himself as trustee. Therefore, the disposition of the shares failed as being an imperfect gift, and this is due to the fact that the wrong modes of benefiting were used. Lord Justice Turner in this instance agrees that the court will not interpret it otherwise by giving effect to it by using another means of transfer if the settler meant it to be a gift. This illustrates the maxim, equity will not perfect an imperfect gift, for then every imperfect instrument will be made effectual by being converted into a perfect trust, and the court does not bound to provide remedies, as equity will not assist a volunteer. Besides, in order to render a voluntary settlement valid and effectual, the settler must have done everything which, according to the nature of the property compromised in the settlement, was necessary to be done in order to transfer the property and render the settlement binding upon him. Another case that follows the principle laid down in Milroy and Lord is the case of Refry. It is asserted that the testator had completed documents that were appropriate for the gift's intended use, namely share transfers, that those documents were irrevocable because they were sealed, and that the settler had taken all reasonable steps to relinquish his legal and equitable interest in the shares in favor of the transferees. However, the court in this case took a strict view and held that due to the settler did not acquire the Treasury's approval, he did not take all the necessary steps to fully divest himself of the equitable interest in the shares in favor of his son. This is because the Treasury might have required further information or answers supplemental to those which he had given. Therefore, there had not been a complete transfer of the equitable interest to the son. It can be seen that law is made more definite by the stringent standard established in Milroy and Lord. However, there are several exceptions that have been established to the maxim equity will not assist a volunteer and equity will not perfect an imperfect gift. The first exception is if the settler has done everything necessary for the transfer, which can be seen in the case of Rose. The question in this case is, who was legally entitled to the shares since the testator made a specific request of shares in his will, but also has a residuary clause involving those same shares in the legatee favor prior to his passing. The testator did not intend for the effectiveness of his gift to Mr. Hook to be contingent on whether it was finished before or after his passing. He had done everything in his power prior to his passing to divest himself of the shares in favor of Mr. Hook, but the completion of the legal title through registrations in Hook's favor could only be accomplished by the Director of Shares Limited. The testator in this case had done everything in his power to divest himself of the shares, and the act to perfect the legal title was not left to his discretion but rather the director's. Therefore, it was held that the shares were gifted to Mr. Hook during his or her lifetime and the residuary legatees had no rights to the shares. This case differed from Refry in that the testator in this case had done everything in his power to divest himself of the shares, whereas in Refry, the flaw was the failure to obtain the consent of the Treasury, which was necessary according to the regulation. Justice Brown also agreed with this view such that a donee won't get a court of equity order if one is required in order for him to fulfill his title. The gift is completed if the donee possesses everything under his control that is required to fully establish his claim without any more aid from the donor. The expected standard on what is considered everything necessary was pointed out in the case of Pennington and Wayne, where the court held that this occurs when a donor's decision to back out of the donation becomes unconscionable. The vague, abstract, and ambiguous nature of the new test is one of the ruling in Pennington's most remarkable aspects, which was heavily criticized. According to Lord Justice Arden, the court's assessment of all pertinent elements must be used to determine whether a donor's decision to change course is unconscionable. The donor is acting in an unconscionable manner when the donee has within his control all those things necessary to enable him, the donee, to complete his title, according to Justice Brown, in Maskell and Maskell. Due to its deviation from the do everything necessary standard set in Rose, the Court of Appeal in Pennington and Wayne had adopted a very mistaken interpretation of the previous authority. This is because there was a declaration of trust in the case of T. Choitram International SA and Pagarani, which contrasted with Pennington, where neither a gift was made nor was the donor doing all in her power to make a gift. The judgment was a gross misinterpretation of that case. There was a criticism on the decision in this case as it causes confusion by not defining a clear standard. The court's error in allowing the flawed gift to be perfected on the grounds of unconscionability. According to an article, the concept of unconscionability is not inherently ill-founded. However, addressing it in general terms without a defined test helps little to explain the applicable legal standards. Besides, the trust acknowledged in Re Rose was likely a constructive trust that only existed while the formal title was being perfected. Despite the fact that the trust created by the laws in Re Rose and Pennington are both typically considered as constructive, their respective roles are very different. An equitable stake in the shares is created by this trust. On the other hand, Re Rose was seen by Lord Justice Clark in Pennington as an illustration of a purposeful transfer of an equitable interest. Re Rose looked into the process the donor took to change the legal ownership of the shares. The entire title to the property was plainly meant to be transferred by the donor. His intention was to give rather than to establish a trust. Therefore, in actuality, Lord Justice Clark's intentional transfer view of Re Rose in Pennington's case promotes interpreting evident donative intent as a statement of trust, which is in conflict with Milroy and Lord. Constructive trust avoids the issue because it develops through the operation of law, regardless of the purpose. Unconscionability and the appropriate jurisdiction of equity to perfect flawed gifts are likely to remain opaque until we have a Supreme Court authority on the subject. The next exception is through fortuitous vesting of legal title in a trustee. The phrase fortuitous vesting of legal title in a trustee describes a circumstance in which a trustee or fiduciary unexpectedly and accidentally acquires legal ownership or title to the property. Even though it was not the settler's initial purpose or goal, this might happen as a result of certain events or circumstances that cause the transfer of legal title. This will frequently happen since the personal representative of the transferor's estates also serves as the gift's intended receiver. Legal title to all of the transferor's assets passes to their personal representative upon death so they can manage their estate. If the transferor personal representative was also the beneficiary of the gift, it may become finalized upon the transferor's passing. For instance, in the case of Re Raleigh Wills Trust, the settler's son-in-law was fortunate to obtain the share of the settler residuary estate, which was not intended for him, but the settler's daughter, which has passed away due to him being appointed the sole trustee of the settler's will, and beneficiary also appointed him as trustee during her marriage settlement and subsequently passed away. The next exception is donatio mortis causa. The idea of donatio mortis causa is one of the few instances where equity will support a volunteer and not require adherence to rigid rules. Due to the restricted circumstances in which donatio mortis causa, or gift with a view to death, can be made, it is frequently referred to as a deathbed gift. Because the doctrine sits on the outside edge of both inter vivos and testamentary trust, it can be compared to a secret trust. They are shared with the recipient while the donor is still alive, but they do not take effect until after their passing. A donatio mortis causa has the benefit of waiving transfer procedures as long as there's a clear purpose to make the gift and some proof of a real or constructive transfer of control of the subject matter. Depending on the property in question, the transfer's exact nature could change. The criteria to establish this concept were set forth by Lord Russell Chief Justice in Kane and Moon. First, the gift had to have been given while being considered, albeit not necessarily with death in mind. Second, the subject matter must be delivered to the donee. This refers to the actual delivery of the gift's content with the intent to part with dominion. It can be either physical delivery or constructive delivery. Finally, it must be conditional upon death and can be reversible till that event occurs. This means that the donor could revoke the gift at any time before his passing, and the gift will be automatically revoked if the donor has recovered from his or her possibly terminal illness. When the subject matter is chattel that the donee has received, the title is completed upon the donor's passing. In the case of land, the donee's title is incomplete following the death of the donor, and the donee may seek the help of equity to complete the donee's title based on the doctrine donatio mortis causa. This was due to the landmark case of Sand and Hadley, where the doctrine was extended to real property. The Court of Appeal in Sand's case overruled the previous High Court decision. It was held that, as a trust formed under a donatio motis causa was imposed by force of law, Section 53 Clause 1 of the LPA could not apply to defeat a donatio motis causa of land because Section 53 Clause 2 of the Act does not apply to constructive trust. Moving on to the next exception is the rule in Strong and Bird. According to the rule established in the Strong and Bird case, when an incomplete gift is made during the donor's lifetime and the donors name the donee as executor, the vesting of the property in the donee in his capacity as executor may be treated as the completion of the gift. There is a presumption that the donor intended to cancel the debt in this instance. In accordance with common law, the obligation was discharged when the debtor was named executor. If the testator meant to discharge the obligation during his lifetime and that purpose persists after his death, the debtor will not be required to account to the estate under equity. Justice Neville in the case of Rees-Stewart extended the rule of Strong and Bird to all voluntary imperfect inter vivos gift to the person who subsequently becomes the donor executor. When a testator intends to give personal property to someone who will serve as his executor after his death, with that intention remain unaltered, the executor is entitled to hold the asset for his own benefit because the property transferred to the executor at the testator's death completes the incomplete gift made during the testator's lifetime, and the testator's intent to transfer the beneficial interest to the executor is sufficient to offset the equity of beneficiary. On the other hand, the case of Rees-James expanded the concept to include the appointment of a debtor as the administrator of a creditor's estate. It was held that the legal estate acquired by an administrator is equally as effective as an executor designated by the will to complete an imperfect gift made to the administrator by the estate's deceased owner. The legitimacy of extending the norm to the administrator, however, was questioned by Justice Bolton in the case of Rigoni. Since the executor was chosen by the testator but the administrator was not, and because it is uncertain who will become the donor's administrator, this will likely result in fortuitous vesting. This principle in Strong Bird was affirmed in Malaysia in the case of Sheikh Hassan bin Abdullah Al Jofri. In summary, for the rule to be applicable, it must be demonstrated that the donor had an intention to make an instant lifetime gift or to discharge a debt and the intention remained unchanged until his death. We will now move on to the final exception, which is proprietary estoppel. The notion of estoppel can be used as a tool to avoid formalities and create trusts or gifts that are imperfectly constituted. It functions to avoid the assertion of a party's stringent legal rights in situations when doing so will be unethical. In Tonner and Major, Lord Walker outlined the essential elements of proprietary estoppel, where there is an express or implied assurance made to the claimant and reliance on it by the claimant, cause a change of position or detriment due to the assurance. The case of Bauxite Trading Sdn Bhd and Arat Malaysian Merchant Bank Berhad confirmed the application of the estoppel principle in Malaysian context. The concept, in the opinion of the court, covered both representation of facts and representation of law. Furthermore, the plaintiff who brought up the theory simply needs to demonstrate that he was persuaded by encouragement or representation that the representative enforcement of his strict legal rights would be impermissible. He need not demonstrate that he was coerced into acting in that manner. The doctrine of estoppel does not include the element of detriment, which was slightly different than the UK position. In conclusion, my opinion, the maxim of equity will not perfect an imperfect gift and equity will not assist a volunteer does not contradict a settler's intention. It is a guide which the court follows to uphold justice. It should not be the court's responsibility to perfect all the imperfect gift if it was due to the settler's negligence, and the court should not be biased by assisting the volunteer. However, to ensure justice and fairness are upheld, court will allow such cases subject to those exceptions mentioned above. However, there might be situations where the court is unable to give effect to the dispositions due to insufficient evidence or the situations do not fall under the subject of exceptions. For the rule of the maxim to apply, in these circumstances, it can only be said that the maxim did not contradict the settler's intention, but due to the settler's negligence or failure to abide by the proper legal framework, causes the disposition of gift or trust to fail. That's all for my presentation. Thank you.